procedural details, and we'll try to avoid procedural details in this lecture as much as possible. I don't want you to fall asleep. But there are a few issues in terms of procedure which are actually quite substantial also in terms of the political nature of what the court system is about. First of all, it means that it is a court that in principle involves all states in one way or the other, by the way that every state is entitled to send one judge to the court. So we have a substantial court of 47 judges. It is not a small bench of the wisest men of the continent. It is a selection that tries to balance the different backgrounds, the different legal systems, the different problems and issues in each state by allowing each state to send a judge. Those judges have all the qualities of judges as international. They're independent. They are being secured by immunities on the national and international level. They are not tempted to run for a second term because there is a single non-renewable term of 1 year, so that's it. They are not only entitled to independence and impartiality, they are required not to act in a manner that infringes in any way with their independence and impartiality. So that means they may not hold any other offices. They may not even perhaps come from offices which would make it troublesome that their independence and impartiality is being questioned. And some sort of other qualifications, legal qualifications. But you don't necessarily have to be a judge, but you have to be an expert in law. Expert in law being understood in the national law that you have. So usually it comprises judges, retired high court judges, high quality legal officers, etc., etc. That of course sounds all wonderful, but how do you get these wonderful, independent, knowledgeable, expert, wise judges to Strasbourg?
All the members have to be lawyers?
All the members do have been lawyers or have legal professional legal training or legal expertise. Lawyers not necessarily in the sense of having a law degree, but having sufficient legal experience. Usually, it's hard to think that they wouldn't have a law degree. All that is a bit troublesome, by the way, that these judges are both to Strasbourg, because who is going to propose who is going to be a judge? But of course, it will be the member states. So the judges are being nominated by the member states, and what is usually done is a list of 3 members. When no other qualifications other than a gender balance is required, so the practice is that there must at least be either one man or one woman on the list, so that you have a gender balance. Otherwise, the Parliamentary Assembly gets angry. This has been the case for Malta. Malta has at some point refused to put a woman on the list 2 or 3 times. And the Parliamentary Assembly got very angry by the argument that there is a single female lawyer in the island of Malta that is qualified to sit on the court, so that was an issue. Other than that, states are basically free to nominate whoever they want, which does pose problems in reality. Because many states would, for example, look towards some kind of political distribution, so that judges named by the 2 major parties are there, or other regional or problematic issues. There's not much really the court can do about that, because the election is done by the Parliamentary Assembly, so it's about the Parliamentary Assembly to reject or to accept. A practice has developed more recently that, and that's quite interesting, that the Parliamentary Assembly asks a panel of allegedly independent other judges from other courts what they think about the nomination list. So that, of course, is sociologically also very interesting to see how other judges talk about judges being nominated and then discuss what the quality of a judge is. That has never been the case so far. It's the case now increasingly. It's an interesting exercise. It's not much successful, really, because states do what they do anyway, because the Parliamentary Assembly would then also have majorities. But it allows a discussion, apart from the question of what is a good quality judge in an international human rights court. Is it about legal qualities, or is it about being human rights friendly, or is it about being a human rights advocate? These kind of things come to the forefront. Yeah. But there's an assumption that you would be human rights friendly and that you would be a good judge at the court, but there is no criteria for that. You just have to be a good lawyer. And hence you see also the dissenting opinions and so on. And that is how you become a judge.